Very well. Here's the judgment of the court. By a general form of complaint filed on the 4th of March 2019, the claimant approached this court claiming the following. A declaration that the indictment of the claimant by the defendants on allegation of fake or forged certificate is without fair hearing and is in breach of her fundamental rights enshrined under the 1999 Constitution. B, a declaration that the dismissal of the claimant by the defendants on the basis of the indictment of the claimant by the defendants on allegation of fake or forged certificate without fair hearing is unwarranted, unlawful, null and void. C, an order setting aside the letter dismissing the claimant from the employment of the defendants and reinstating claimant back into the service of the defendants forthwith. D, an order directing the defendants to pay to the claimant all the claimant's monthly salaries and allowances which were due to her from the month of January 2018 to the date of judgment and thereafter until compliance with the judgment of court. E, the sum of 5 million naira being the cost of the suit, and F, 20% interest per annum on the judgment sum until final liquidation of the judgment sum by the defendant. It is the case of the claimant that she was a confirmed employee of a defendant employed as personal assistant 3 on grade level 04, step 1, and rose through the ranks to the position of personal assistant 1, grade level 6, on a monthly salary of 32,000 naira. It is a case that she got admission to study economics/political science in Kogi State College of Education, ANKBA, and having satisfied all the necessary requirements after the completion of her studies, she was issued a testimonial certificate of completion of NCE course, and was equally issued an original certificate of Nigerian Certificate in Education in July 2013. However, in the month of January 2018, her salary and allowance were not paid. And after inquiry, she discovered that her salary was deliberately withdrawn by the defendants on the account of an alleged irregularities in her certificates, that her certificate was forged. She also averred that the defendant issued a circular, which she was unaware of, on the 2nd of August 2018, inviting all staff with forged certificates to appear before the Certificate Verification Committee, which circular was brought to her attention on the 10th of August. Claimant visited the local government to confirm it, as a result of which she rushed to Lokoja to submit a certificate, but on getting to Lokoja, the committee had risen, but was advised to submit her certificate, which she did. She asserted that she had written a letter denying the allegation of fake NC certificate dated 21st March 2018. She also stated that she was unable to appear before the committee because she had to travel down to Ankara to retrieve her certificate at Kogi State College of Education, and on getting back to Gualawu, where the screening was taking place, the screening exercise had been concluded that the head of local government administration, who is a member of the screening committee whom she met at the venue, advised her to forward the certificate to the third defendant, which she did. She maintained that all her certificates are genuine and authentic, as she was employed and got promoted based on their certificates. That despite all her explanation and presentation of certified true copy of her NC certificate, defendants went ahead to dismiss her from the employment of the third defendant on the 6th of December 2018. The defendants, on their part, asserted that prior to withholding claimant's salary in January 2018, she had already appeared before a staff screening and verification committee in 2017, where she was indicted of fake or forged certificate before the publication in Leadership newspaper, and that the defendants, in order to entertain genuine complaints as regards the publication, issued a circular on the 2nd of August 2018, inviting the affected officers to appear before its committee. They averred that they were in receipt of claimant's letter dated 21st March 2018, and in fact shortlisted her among those who were to appear before the junior management committee to defend herself, but she willfully absented herself by not appearing before the committee to present her case that was captured in the report of the committee. They stressed that since 9th of August 2018, when the committee sat, till the 6th of December 2018, when claimant was issued with a letter of dismissal, she failed to make any effort to explain why she was absent at the sitting of the committee. Failure of the claimant to avail herself of the opportunity given to her led to the issuance of a letter of dismissal on her. They maintained that in order to ensure that no one was unlawfully removed, the defendant put in measures in place, which includes continuous verification and screening exercise to entertain those with genuine claims, and the extension of the years of service of the head of service to enable her conclude hearing of the various petitions, and claimant failed to avail herself of all the public hearing before instituting her action. On the 4th of December 2022, Counsel for Parties voluntarily consented to adopt the argument on record procedure pursuant to the 38 through 33 of the National Industrial Court Civil Procedure Rules 2017, the import of which is that the case is to be tried on record without the need to call oral evidence or cross-examination. The court is usually to rely on the pleadings of parties, sworn witness statement of parties, as well as documents front-loaded in support of their respective cases. However, claimant in this case took it upon herself to forward original copies of documents front-loaded to the court, and which became part of the record of this court. Parties were then ordered to file their final written addresses, as it is customary to do under the argument on record procedure. The claimant filed first. I have reduced all the pertinent parts of his final written address into the body of this judgment. The defendants equally responded, filed, and the claimant filed a reply on point of law. I've reduced all that into the body of this judgment. I will then go straight to the decision of the court. Upon giving the case at hand an in-depth consideration, the court is of the humble view that the issue that will best determine this case is as follows: whether claimant has proven her case on the balance of probabilities to be entitled to the relief sought. On the preliminary, let me say one or two words about the state of pleadings of parties in this case. Claimant in this case amended her statement of facts twice. The last amendment was done by the order of court made on the 15th of November 2022. The court had ordered that defendants were at liberty to file a consequential amendment to their defense on the 15th of November 2022. The defendants did not file any consequential amendment to their defense. Their extant process is the amended statement of defense filed on 10th of June 2020, which is at pages 125 to 127 of the record. And it was filed in response to a previous amendment made by the claimant. The point must be made that it is not compulsory for a party in a case to amend its process upon the amendment of the process of its adversary if it feels its process sufficiently answers to the amended process. The only effect of failure to amend a process upon amendment of the process of an adversary is that such a party will be taken not to have joined issues on the new issues raised by the amendment. See the case of Afemi Hai and Orders versus Stanbic IBTC, citation captured, Usman and First Bank and Orders, citation captured, Mobile Nigeria PLC versus IAL 36 Incorporated, citation captured. Thus, even if the defendants did not file a consequential amendment to their statement of defense upon the amendment of claimant's statement of facts on 15th of November 2022, they are still deemed to have defended this action. It is also worthy of note that several months after claimant was granted leave to amend her process and has indeed amended same, on the 15th of November 2022, this matter came up for hearing on 22nd February 2023, and parties consented to the argument on record procedure pursuant to the 38 and 33 of the rules of this court as stated earlier, which signifies that those pleadings have closed and the court subsequently adjourned to adoption of final written address. However, claimant after the said date, on the 3rd of March 2023, purportedly filed a reply to the amended joint statement of defense of the defendants, which amended statement of defense has been filed since 2020, even before claimant amended her statement of facts. It is important that I produce at this stage the excerpt of Order 38 to 33 of the rules of this court does, I quote, "In any proceeding before the court, parties may by consent at the close of pleadings agree to a trial on records where they rely only on the documents and exhibit front-loaded and thereby dispense with the need for oral testimony and or cross-examination." Trial on records written address. Subsection 2, quote, "Where parties agree to a trial on records, written addresses shall be filed starting with the claimant on the basis of a document on record." Subsection 3, "The written address which shall be in the format provided in Rule 2 of Order 45 of these rules shall be served first on the defendant in compliance with the provisions of Rule 20 of this order," unquote. It is clear from the above that trial on record procedure is usually adopted after the close of pleadings when parties have exchanged all their pleadings. Claimant who consented to the argument on record procedure on the 22nd of February 2023 has by implication agreed that as at that very day, pleadings have closed, which means that he has no other pleadings to file again and that the case be tried on record based on the pleadings already filed. It was as a result that the court adjourned the matter for adoption of final written address. Claimant who did not say that he still had a process to file cannot suddenly, few days after agreeing to argument on record procedure, which presupposes that pleadings have closed, decide to file a reply to an amended statement of defense that has been filed since 2020. If he had any intention of responding to that process, he should have done so before agreeing to the argument on record procedure. Claimant has amended her statement of facts since 15th of November 2022, 2 years after the defendants amended their statement of defense. So by her amendment, she's expected to have captured whatever she intended to aver in support of her case and also to meet the case of the defendants, as she might have desired. Meanwhile, learned counsel for the claimant agreed to the argument on record procedure on the 22nd of February 2023, which was after she filed her second amended statement of facts. What is more, learned counsel did not ask the court to vacate its last order and did not seek the leave of this court to file her reply to the defendant's amended statement of defense after pleadings was already settled and closed. This court finds that the reply of claimant to the amended statement of defense of the defendants filed since 2020, after claimant has amended her statement of fact for the second time on the 15th November 2022 and pleadings settled, while the case was adjourned for adoption of final addresses, is not competent and thus discountenanced. Therefore, the only competent processes before this court are the amended statement of facts of claimant of 15th of November 2022 and the amended joint statement of the defendants filed on the 10th of June 2020. Now to the merit of the case at hand. The point must be made that claimant in this case sought declaratory reliefs. It is settled law that the onus is on the party seeking declaratory reliefs to justify his or her entitlement to same. Thus, such a party must rely on the strength of his or her own case and not on the weakness of the defendants. See the cases of Ani and Efiok, citation captured, Akugo and Goji, citation provided, Messrs. Singles and Company Nigeria Limited, versus UM and Co. Limited, citation captured, Emenike and PDP, citation provided. However, the law does not preclude such a claimant from taking advantage of aspects of a defendant's case which support his or her own. See the case of Idris and CNS, citation captured. The case of Kashamba and Anoda versus Issa and others, citation also provided. Claimant in this case is alleging her unlawful dismissal by the defendants. It's the law that where an employee alleges unlawful termination or dismissal, such an employee has the rules to prove same. Specifically, the Apex Court in the case of Olorun Toba Oju and Abdurrahim, citation provided, held that the onus is on an employee to prove that the termination of his appointment is unlawful, and to discharge this body, claimant must prove one, that he is an employee of the defendant. 2, the terms and conditions of his employment. 3, the person who can appoint and remove him. And 4, the circumstances under which the appointment can be determined by the employer. See the case of Iwaram Nigeria Limited and ROCG, citation provided. Kato and CBN, citation provided. In Wachiko and in Wizu, citation captured. Moronfola and Kwara State College of Technology, citation provided. By the Case Law Authority of OPVA and others, and Delta Steel Company Limited is a recent decision of the Apex Court. The Apex Court reiterated its position in the case of RG and Chad Basin Development Authority and another, and the case of Moronfola and Kwara State College of Technology, Supra, at page 116, paragraph 8, held that, I quote, in an action for wrongful dismissal, it is necessary to plead the contract of employment, which is the foundation of the action. Without the contract and its particulars being pleaded by the plaintiff, no evidence of the terms of the contract which has been breached will be admissible at trial, and this will be fatal to the action since it will lack foundation, unquote. Claimant in this case only tendered before this court her letter of employment book as a front-loaded document and also forwarded an original of same to this court as part of the bundle of documents relied on in this case. This shows that he was an employee of the first defendant. Claimant read paragraph 30 of her amended statement of fact at page 171 of the record. Averred that her employment is one with statutory flavor and shall at the hearing of this suit rely on the condition of service applicable to her employment. It is important that I capture the said averment as contained in paragraph 30 of the amended statement of fact, and it says thus, I quote, the claimant avers that the claimant's employment is with statutory flavor. Claimant shall at the hearing of this suit rely on conditions of service applicable to the claimant's employment. The defendants are put on notice to produce the said documents at the hearing of the suit, unquote. The above averment, in my view, is vague, as it is not referring to any particular condition of service as the one governing claimant's employment, but only stated that she will at the hearing rely on the applicable condition of service governing her employment. And this will not, in my view, satisfy the requirement that she has the onus to plead and prove the condition of service. She did not state specifically the condition of service applicable to her employment. I believe she did not expect the court to speculate as to what document constitutes her condition of service. It is equally worthy of note that claimant did not place before this court, whether as part of the documents front-loaded or as part of the originals forwarded to court, the condition of service she referred to is that governs her employment. I do not lose sight of the fact that claimant read the same paragraph 30 of her amended statement of fact earlier referred to, gave the defendants a notice to produce the said document which was not done. The position of the law is clear, that a person on whom a notice to produce is served is not obliged to produce it. The law is now settled that the service of notice to produce pursuant to Section 91 of the Evidence Act 2011 does not compel the parties served to produce the document. Rather, it entitles the parties serving the notice to produce secondary evidence of the document in question. So the case of Kwara State Teaching Service Commission and GTB PLC, citation provided. In this case, claimant who pleaded the existence of the condition of service governing her employment with the defendants and gave the defendants notice to produce same means that the document was in existence. Claimant did not tender at least secondary copy of the said condition of service which existence she pleaded. The Supreme Court in the case of Nweke and the state citation provided have held that it is unnecessary to serve a notice to produce when secondary copies of the document is not in possession of the party serving the notice, as the notice does not place an obligation on the party served to produce it. In effect, the service of notice to produce does not relieve the person serving the notice of the burden of producing the document if he can or proving its content. As such, failure to produce or non-response on the part of the party served with the notice will not cause the court to invoke the presumption of withholding evidence under Section 167, paragraph D of the Evidence Act against the party in default. See these cases: Abimbola and the state citation captured, Buhari and Obasanjo citation provided. Specifically, Begore JLC, EGN retired. In the case of Buhari and Obasanjo Supra, at pages 198 to 199, paragraph 8 to C, held us as regards the effect of failure to respond to notice to produce, and I quote, in notice to produce procedure, it is supposed that the person asking for the document knows of the contents, perhaps has a copy of it. If the person fails to produce it, the secondary evidence of it can be admitted in evidence. Chief John Ukpa of the ANPP, if he actually wrote the letter of protest in question, could bring the copy of it for admission. Either the letter did not exist or it existed, but Chief John Ukpa refused to bring its copy. If he brought the copy, the presumption can as well be that the content would not have supported the case of the appellant. The provision of Section 149 of the Evidence Act is of no use to the appellants, unquote. It is the unwavering view of this court that claimant has a duty to plea and place before this court a particular condition of service governing her employment. I also bear in mind the submission of learned claimant counsel in paragraphs 4.1.2 of his final written address that it is the public service rules as applicable in Kogi State that regulate discipline of employees. I've also taken note of his submission in paragraphs 4.1.3 that the dismissal of the claimant was done in contravention of Rule 03042 and 03043 of the public service rules, as claimant was not given clearance. First, let me say that address of counsel, no matter how beautifully written, cannot take the place of pleadings or evidence where there is not. Put differently, address of counsel is not a substitute for pleadings or evidence. Thus, a party cannot use this address to introduce facts or evidence which were not needed or introduced during trial, on which parties never join issues on. See the case of Ubani and Pomo, citation captured. The case of WDP Development Company Limited and Trade Wheels Limited, citation provided. The case of Uban Uzibo, citation captured. Oyemi and Uweye, citation provided. And the case of Badamosi and Tolani, citation also provided. It is also the law that address of counsel must be based on pleaded facts. See the case of Kwara State Teaching Service Commission and GTB Supra. The case of CCB and Onyekwelu, citation provided. Also, parties, including their counsel, are bound by their pleadings and cannot set up a case outside the one set up in their pleadings. Thus, same as raised in the address of learned counsel is discountenanced. Equally, the reliance of claimant counsel on the public service rule of Kogi State will not exculpate claimant of the consequence of failure to plead and prove the particular condition of service that governs his employment. Learned counsel had in paragraph 4.1.2 of his final written address while relying on an earlier decision of this case. On an earlier decision of this court. In the case of Ebuche, Stephen, and Kogi State government and 3 others, even though he failed to produce a certified true copy of the judgment, nonetheless, the point needs to be made that cases are authorities for what they decide, as it is the facts and circumstances of the case that determines whether it will be applicable as a precedent in subsequent cases. Those authorities ought to be thought not to be cited or applied outside their actual context. See the case of FRN and Nwosu, citation provided, Buhari and INEC, citation provided, Adegoke Motors and Adesanya, citation captured. In the case of Ebuche, Stephen, and Kogi State and 3 others, Supra, which learned counsel relied on to say that the condition of service that governs claimant employment is Kogi State public service rules. The applicability of the public service rules was specifically pleaded by claimant in Eguche's case supra. In fact, the claimant in that case pleaded the particular provisions of Kogi State public service rules that were not complied with by the defendants in the termination of his employment. None of this was done in the instant suit. Failure of claimant to plead the particular condition of service that governs her employment and her failure to prove the particular condition of service she is relying on is fatal to her case. It is also the contention of claimant that her employment is one with statutory flavor. Claimant hearing, according to her uncontroverted abatement was employed on grade level 4 and rose through the ranks to level 6 in the service of the defendants. Employment relationships are basically divided into 3 categories, namely A, purely master and servant relationship, B, employment at the pleasure of the master, and C, employment with statutory flavor. See the case of VBA and others and Delta Steel Company Limited Supra, Ituen and Ikot Local Government Council, citation captured, notorious case of Lunga and FBN PLC, citation provided. It is tried that an employment is said to have statutory flavor, and the appointment and termination of such employment is governed by statutory provisions. In other words, where the contract of service is governed by the provision of statute, or where the condition of service are contained in regulations derived from statutory provision. See the cases of Controller General of Customs and Orders and Gusel, citation captured, Imolame and Waek, citation provided, notorious case Olanyo and University of Lagos, citation provided. The point must be made that the mere fact that an employer such as Abela, the creation of statute, does not cloak the contract of employment entered into with statutory flavor. See the case of Vivian, Orders and Delta Steel Company Limited Supra, PHCN of the 4 citation provided, Petroleum Equalization Fund Management Board and another citation captured. The case of Fakwadi and Obafemi University Teaching Hospital Complex Management Board, citation provided. The Apex Court in the case of Para State Judicial Service Commission and Solani Supra held that there are 2 elements that coexist where a contract of employment can be said to have statutory flavor, and these are A, the employer must be a body set up by the Constitution or statute, and B, the statute or regulations made pursuant to the Constitution or principal statute or law must make provision regulating the employment of the staff of the category of the employee concerned, especially in matters of discipline. From the letter of employment of claimant, which is before the court, she was employed by the 3rd defendant, which is established by Section 7 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, hereafter referred to as the Constitution. Specifically, Section 7 of the Constitution provides that the system of local government, democratically elected local government, is guaranteed under the Constitution, and accordingly, the government of every state shall, subject to Section 8 of the Constitution, ensure their existence under a law which provides for the establishment, structure, composition, finance, and functions of such councils. See also the case of Friday and Governor of Ondo State, citation captured, and the Kogi State Local Government Law 2002. The 3rd defendant, who is the employer of claimant, is no doubt a creation of law as seen in Section 7 of the Constitution. However, that alone will not cloak the employment of claimant with statutory flavor. The conditions of service regulating our employment must be one contained in the statute or made pursuant to a legislation as reason supra. Claimant in this case has failed to plead or place before this court the particular condition of service regulating our employment as stated earlier, from which the court will make a finding that our employment is actually one laced with statutory flavor. There's nothing before the court to show that any condition of service which has statutory flavor was incorporated to claimant's employment. In fact, claimant's letter of employment, which is before the court, did not allude to any condition of service. Claimant herself, as reading supra, did not state, be it her pleadings, that Kogi State Public Service rules is the applicable condition of service governing her employment. In view of the above, this court, in spite of the fact that claimant's employment is the creation of statute, cannot make a finding that claimant's employment is one with statutory flavor, as claimant has not proven same. Claimant, by her relief A, in her amended statement of facts, is seeking for a declaration that her indictment by the defendants on the allegation of fake or forged certificate is without fair hearing and in breach of her fundamental rights. It is the position of claimant by her amended statement of facts that the defendant has stopped her salary and published her name in the leadership newspaper as one of those who forged the certificates. Claimant forwarded an original leadership newspaper publication of the 14th of November 2017 to this court. Although claimant did not state the particular page where her name was written, she merely stated that her name was on line 94 in the newspaper. I've gone through the pages of the newspaper and I found that claimant's name is captured at page A39 on line 94 of the newspaper. She also averred that she had written a letter dated 21st of March 2018 denying the allegation of forged certificate. Defendants on their part maintained that before claimant's salary was withheld, she has already appeared before a staff screening and verification committee in 2017, which indicted her of forged certificate, pursuant to which the publication in the newspaper was made. This part was not controverted by claimant in this case at any time. It is the law that facts not denied are admitted. See the case of Husseini and Atta, citation captured. APC and Jega, citation provided. The case of First Equity Security Limited and Nozie, citation captured. The case of Ogunleye and Oni, citation captured. In fact, I must say that the leadership newspaper publication of November 14, 2017, which claimant herself tendered in support of her case, is a document which speaks for itself. It is clear that there was a staff audit and verification exercise that was conducted in 2017 because it was conspicuously stated therein in the newspaper that the publication is pursuant to the staff audit and verification exercise that was conducted before the publication. This supports the assertion of the defendants that the claimant had participated in a staff verification and screening exercise in 2017, which indicted her on the allegation of fake and forged certificate. In view of the above, this court cannot find that the indictment of claimant on allegation of fake or forged certificate was in breach of her right to fair hearing, since it has been shown that she did take part in a verification and screening exercise in 2017 before the said publication. Therefore, relief A fails. In her relief B, she is seeking a declaration that her dismissal by the defendants on the basis of the indictment on allegation of fake or forged certificate without fair hearing is unlawful, null and void. It is her contention that she had written a letter dated 21st March 2018 denying the allegation of fake or forged certificate made against her, and that the defendants are in receipt of same. It is equally her contention that a circular, which she was unaware of, was issued on 2nd August 2018 by the defendants for all those affected to appear before a committee, and the circular was brought to her attention on the 10th of August 2018 upon her visit to the local government, and as a result of which she rushed to Lokoja to submit her certificate, but was told the committee had risen. That she was late in appearing before the committee because she had to travel to Ankpa to retrieve her certificate at Kogi State College of Education, Ankpa, before proceeding to Ugwalawo, where the screening was taking place. Defendants on their part averred that they were in receipt of claimant's letter dated 21st of March 2018, and in fact shortlisted claimant to appear before the Junior Management Committee to defend her case, but claimant willfully absented herself from appearing before the committee and also did not meet with any member of the committee thereafter. Let me say at this stage that I agree with learned claimant counsel that an employer must justify the reason given for dismissal or termination of employment, or that the employer is to establish to justify the dismissal or termination of appointment is to show that 1, that the allegation was disclosed to the employee, 2, that he was given a fair hearing, and 3, that the panel believed he committed the offense after hearing witnesses. See the case of Ahmed and Federal Civil Service Commission and others, citation captured. Bisong and Unical citation captured Olorun Toba Oju and others Naburahim and others Supra. Answers to these questions will be revealed hereafter. According to claimant, she only became aware of the circular of 2nd August 2018, which invited her to appear before a staff verification committee on the 10th August 2018 when she went to the local government. See paragraphs 22 to 23 of the amended statement of facts. Let me say that the fact that claimant was not aware of the circular only came up in the extant amended statement of facts of the claimant. In fact, it was one of the new facts introduced by the amended pleading of the claimant to which the defendant did not file a consequential amendment. As reasoned earlier in this judgment, failure to file a consequential amendment to the extant amended statement of facts of the claimant means that the defendants have not joined issue to the extent of the new issue raised, and which in this case is the fact that claimant was not aware of the circular of the 2nd August 2018, which ordered her to appear before the committee. Ordinarily, failure to join issue on this issue is deemed an admission. However, since this action is declaratory, the claimant must rely on the strength of her own case and not on the weakness of the defendants, and as such, will not even succeed even on the seeming admission by the adverse party. Claimant still has to prove her assertions to the satisfaction of the court in order to be entitled to relief sought. See the cases of Annie and Efiok Supra and Apugu and Ugoji Supra. It is worthy of note that in subsequent paragraphs of claimant's amended statement of facts, she averred that when she got to where the screening was taking place, she was told the committee had risen and that she was late because she went to collect her certificate from school in Ankpa and then back to Ugwalawo, where the screening was taking place. This, to my mind, means that claimant only excuse for not appearing before the committee was that she came late because she went to get her certificate and so she got to the venue late. See paragraphs 25 and 26 of the amended statement of facts. From the document front-loaded by the defendants at page 133 of the record, the said sitting of the committee before whom claimant was to appear took place on the 9th of August 2018. This fact was equally corroborated by the content of claimant's letter of dismissal, which states that the Junior Staff Management Committee sat on the 9th of August 2018. It is therefore without doubt that the said committee sat on the 9th of August 2018. Now, the question that comes to mind is if claimant is saying she only became aware of the circular asking her to appear before the committee on the 10th of August 2018, then it means that she only became aware a day after the committee had sat on the 9th of August 2018. Then if truly she only became aware a day after the committee had sat, then she would not say her only excuse for not appearing before the committee was because she went to get her certificate from Ankpa, and so she got to the screening venue late. She would have averred that she became aware of the sitting after the committee had sat and could not have possibly appeared before the committee when she was not even aware of the sitting. The averment of claimant in this regard are not consistent. Again, one of the documents which claimant is relying on in this case clearly shows that the letter of the school, that is the College of Education, Ankpa, forwarding a photocopy of a claimant's certificate and authenticating same, was written on the 9th of August 2018, which was one of the documents claimant allegedly rushed to get from Ankpa before going for the screening. Now, if it was after claimant was reportedly told on the 10th of August 2018 about the circular which required her to appear before the committee that she went to school to get the said letter, how come the letter which she went to get was dated 9th of August 2018, the day of the sitting of the committee, which is the day before the alleged 10th of August 2018 visit to the local government? The defendant had averred, read paragraph 12 of the amended statement of defense at page 126 of the record, that from when the committee started on the 9th of August 2018 to the 6th of December 2018, when claimant was dismissed, claimant never made any efforts to explain the reason for her absence before the committee. Claimant, who would want this court to believe as stated in paragraphs 26 and 27 of her amended statement of fact, that she met the head of local government administration, a member of the Junior Staff Management Committee, when she got to the venue, and the committee had reasoned and he advised her to forward her certificate to the third defendant, which she complied with forthwith, has failed to place before this court any letter which she used to forward her certificate to the third defendant in order to convince the court that she did comply with same forthwith. I say this in view of the fact that the only letter before this court written by claimant after the committee sat on the 9th of August 2018 to the third defendant was written on the 8th of February 2019, which is a year after claimant's dismissal. In fact, a perusal of its content clearly shows that it was written after claimant's dismissal, as claimant therein was pleading that her letter of dismissal be withdrawn and she should be reinstated. Therefore, assuming one would believe claimant's affirmation in paragraphs 26 and 27 of her pleadings, there's nothing to even show that she complied with the directive contrary to her affirmation. She's the one asserting that she complied forthwith with the advice given to her to forward her certificate to the third defendant, and as such, she has the onus to prove same. See the case of Rubicon Properties and Developers Limited and another versus NDCRBD Limited citation captured, Ojo and Kamalu citation provided, Finger Agro Industrial Enterprises Limited and Yusufu citation captured. Her failure to show that she did forward her certificate to the third defendant as asserted is fatal to her case. Also, claimant has stated via paragraph 29 of her amended statement of fact that despite explanations and presentations of certified true copy of her NCE, the defendant still went ahead to dismiss her from service as the letter of dismissal was served on her on the 6th of December 2018. The original copy of the certified true copy of the said certificate was part of a bundle of documents claimant forwarded to this court. I've taken a close look at the certified true copy of a claimant certificate, and it is interesting to note that same was certified as seen on the certification stamp on the certificate and dated 17th of December 2018, which clearly means that the certification was done after claimant had been dismissed from employment on the 6th of December 2018. In effect, claimant only certified her NC certificate after she has been dismissed from employment, contrary to her claims in paragraph 29 of her amended statement of fact as captured above. I must at this stage reiterate the evergreen position of the law, which is that in order to do substantial justice between parties, the court is entitled to look at its file or record and make use of the contents. There are abundant judicial authorities to support this position of the law, and they are Keystone Bank Limited and Abu Gavaru Yusuf and Company Limited citation captured, Barewa Pharmaceuticals Limited and FRN citation captured, Eremosele and FRN citation provided, Abiodo and FRN citation captured, Agbari and another versus Mimra citation provided. In fact, this court, in exercising its powers to go through its record, found out that from the very first time claimant filed her process in this case, her account of appearance before the Junior Management Committee has been inconsistent. In her first statement of facts in this case, claimant averred that she was invited to appear before the Junior Staff Management Committee via the circular which she front-loaded, and pursuant to the said circular, she appeared before the said committee and asserted the genuineness of her NC certificate. I have, in exercise of the powers of the court, to look at documents on record, taking a look at the circular at page 33 to 34 of the record, which claimant in her first process did not deny having knowledge of, and found that claimant name was really captured as part of those invited at page 34 of the record. After the defendants filed their joint statement of defense and contended that claimant did not appear before the committee as she was absent on that day, and even front-loaded a copy of the report of the committee as seen at page 76 of the record, claimant applied to amend her process and changed the narrative in her amended statement of fact, stating that she inadvertently did not appear before the committee as she had to go to Ankpa to get her certificate and as a result missed the sitting, but met members of the screening committee who advised her to forward her certificate to the third defendant, and her effort to present the certificate was rebuffed by the defendant as seen at pages 87 to 117 of the file. The defendant filed a consequential amendment to same and denied claimant, stating specifically that she did not meet with any member of the committee. Claimant, in her subsequent amendment in the extant amended statement of facts, again gave another account that she was not aware of the circular that invited her to the committee until 10th of August 2018, when she visited the local government to make inquiries and then had to go collect her certificate in school, and as a result missed the screening, but she met with the head of local government administration who advised her to forward her certificate to the third defendant, which she did, and that despite the explanations and submission of certified true copy of her certificate, the defendant still went ahead to dismiss her. Specifically, the Court of Appeal, Per Dongban Mensem JCA, now PCA, that is the president of the Court of Appeal, in the case of Olatero Olagbegi 3 and others versus Maja Kodumi, citation captured, while considering a similar issue held us, and I quote, "The primary duty of every court is to do substantial justice between parties. Processes filed in court and placed before a judge must be used to expound and uphold the tenets of justice. While the instrument of amendment is a veritable tool in recognition of the fallibility of man, it must not be used to overreach the other party. Where it appears that the justice of the matter lies in a holistic overview of the processes filed before the court, the judge is at liberty to look into its records and draw the inference relevant to the just determination of the case. In the instant appeal, the learned trial judge pierced the veil of amendment in order to determine the justice of the matter. It has not been shown that his lordship had any motive other than that of justice for drawing the requisite inference from the processes placed before the court," unquote. The above trend discovered from the holistic overview of the claimant processes clearly shows that claimant at different points was changing her narrative as regards her appearance before the Junior Management Committee, which shows inconsistencies in claimant's case. Apparently, claimant's case is riddled with so many dilly-dallying in her attempt to cover up the weakness of her case and overreach the defendants. The Supreme Court, in the case of APC and Sheriff and others, citation captured, held us, and I quote, "Also, it is well settled that the onus is on the party confronted with its self-created contradictions to fully and properly explain away the contradictions to the satisfaction of the court. Failing to do so leaves an indelible dent in the party's case because it is not open to the court to enter into the arena of judicial conflict between the parties in order to resolve the contradictions within the party's own affidavit evidence." Unquote. This was per Wumiju GSC. Obviously, the claimant put herself in the cobweb of the above contradictions in her bid to cover up her tracks, and that has unfortunately put a dent on her case. The court cannot believe such a party. It is in consequence that I discountenance all the assertion of claimant respecting her certificate and her failure to attend the committee meeting. I find it plain on record that the defendants gave him the opportunity to appear before the committee after they had informed her of the allegation against her, but she failed to take advantage of the opportunity given to her. Consequently, I hold that the defendants have justified the reason given for claimant's dismissal. I also do not lose sight of the submission of learned counsel for the defendants on issue 1 and part of issue 2 in his final written address on failure of the claimants to obtain study leave before proceeding to school, and as such liable to be dismissed. I agree with learned claimant counsel in his reply on point of law that learned defense counsel cannot argue on same as parties never join issues on it. As reasoned above, address of counsel is not a substitute for pleadings or evidence where there is none. See the case of Benin and Lokoja and 7 of Bottling Company PLC Supra. The case of WDP Development Company Limited and Trade Wheels Limited Supra. Learned counsel cannot be making submissions on facts which were not pleaded by the defendants and of which issues were not joined by parties. In the case of CCB and Yokwelu, citation captured. Toby JCA, later GSC, now of blessed memory, held those, and I quote, "It is the law that address of counsel is based on pleaded facts. Therefore, where facts are not duly pleaded, counsel cannot introduce them in the course of address. After all, facts belong to the party. What belongs to counsel is the law. It is a combination of facts and law that makes litigation what it really is. The party supplies the facts, and counsel supplies the law, and that makes a beautiful blend," unquote. Besides, in this case where pleadings were filed, address of counsel is not the proper avenue to raise such issues of fact for the first time. See the case of Pesco Industries Limited and Unity Bank PLC, citation captured, Wajafa and others, and Bank of the North Limited, citation provided. Thus, the submission of learned counsel for the defendants on issue 1 in his final written address is discountenanced. I do not feign ignorance of the submission of counsel for the claimant in his final written address that the allegation of forgery of certificate is a criminal one, that only a court of competent jurisdiction can determine, and not the defendant, while relying on the case of CBN and DNA Supra. The point must also be made that the allegation of forgery of certificate, which is the reason given for the dismissal of claimant in our letter of dismissal, is criminal in nature. In the case of Anaja and UBA's PLC, citation captured, the Court of Appeal drew the distinction that where an allegation of crime is made against an employee, it has to be proved in the court of law seized with the jurisdiction to try the offense. But where the allegation is termed misconduct, where any criminal act, then the employer, without any criminal act, then the employer can apply the appropriate sanction to either terminate or dismiss the erring staff. See the case of Wusuku and Civil Service Commission, citation captured, Nasarawa State University and another Nekere, citation provided, Okeme and Civil Service Commission of Edo State and others, citation provided. In the same vein, the Supreme Court, in the case of Awala and Nigeria Telecom Supra, held that any dismissal, suspension, or act founded on criminal allegation by mere administrative panel is a nullity, void, and of no legal consequence. Subsequently, in the case of CBN and DNA Supra, the Supreme Court held that where there is an allegation of criminal wrong against a person, the jurisdiction to determine the allegation is vested in the courts, and the exercise of such jurisdiction cannot be usurped by any administrative tribunal. The court went further that the reason is simple. Where there are series of allegations of crime like fraud and forgery, the matter is beyond the power of an administrative panel. It has to be pronounced upon by courts of law, as the allegations are of serious, requiring proper judicial process in all their ramifications, and that the respondent therein should have been tried by the ordinary court before his dismissal. However, the Apex Court, in its most recent decision on this point on the 27th, a judgment delivered on 27th of May, reported as FRN Nwanjinwa, citation captured, created a dichotomy that where the employee commits an offense, which imparts on his character and his ability to sustain the trust of his employer and his ability to continue to do his job efficiently and effectively, like fraud, stealing, bribery, and corruption, and so on, then the employer is at liberty to disengage the employee before conclusion of criminal proceedings. However, if the criminal offense is one that does impart on the character or ability of the employee to do his job, that does not impart on the character or ability of the employee to do his job, then the employer has to wait for the conclusion of criminal proceedings before the disciplinary proceedings can start. And these are offenses like assault, murder, traffic offense, and so on, and in respect of which the employer has to wait the outcome of the criminal prosecution before any disciplinary proceedings can be initiated and concluded by the employer. This decision of the Apex Court in the case of FRN Nwanjinwa Supra is the current state of the law as it relates to when allegation against an employee borders on crime and the extent of the power of the employer to discipline such an employee. The allegation of forgery of certificate is one that imparts on the character of claimant and her ability to do her job, and as such, the defendants cannot be compelled to charge her before a court of competent jurisdiction before dispensing with her services. It is thus without doubt that the defendant had the power to dismiss claimant without necessarily taking her before the court to pronounce unsafe. It is therefore difficult for one to make a finding that claimant's right to fair hearing was breached before she was dismissed from employment, especially in this case where claimant has failed to even prove the existence of any condition of service which the defendants have contravened, and prove that she had no knowledge of the Junior Staff Management Committee. Accordingly, Relief B failed. Claimant by Relief C is claiming for an order setting aside her letter of dismissal and an order reinstating her back to her employment with the defendants. The law is clear that an order of reinstatement can only be made where termination or dismissal is found to be unlawful in employment with statutory flavor. See the case of Kwara State Judicial Service Commission on Tolani Supra, Nigerian Society of Engineers on Ozar, citation captured, the case of IHAM, ABU, HMB, and Kanyip, citation provided. In the instant case, I've earlier in this judgment found that claimant has failed to prove that her employment was one with statutory flavor. I've also held that claimant has failed to prove that her dismissal is unlawful for being in breach of her right to fair hearing, the effect of which is that claimant cannot be asking for an order of reinstatement. I bear in mind the submission of learned claimant counsel in paragraph 4.1.8 of his final written address that since the originals of the certificates are before the court can peruse same to make a finding whether same are genuine or not. It is the position of this court that claimant in this case did not seek any declaration that the court should declare her certificate genuine or valid. Instead, she sought declarations that the court should declare that her indictment for certificate forgery without fair hearing is a breach of her fundamental rights, and her dismissal based on same without fair hearing is unwarranted, unlawful, null, and void. The court is not allowed to grant a relief or make an order not sought for by any of the parties. See the case of AG Federation versus AIC Limited, citation captured. It is equally not in the place of the court to declare claimant's certificate as genuine. This court is not the issuer of the certificate. Even if the court makes a finding using the presumption of regularity of official documents, as provided in Section 168 of the Evidence Act 2011, that the certificates are genuine, it will be of no utilitarian value to the claimant in this case. This is because this court cannot make an order setting aside the letter of dismissal and an order of reinstatement in view of the fact that claimant has not proven that her employment is one with statutory flavor and that she was unlawfully dismissed. Thus, Relief C must fail. Accordingly, claimant's Relief C fails. Reliefs D, E, and F taken together are for arrears of salaries, cause of action, and post-judgment interests, which are no doubt ancillary reliefs which depend on the declaratory reliefs in this case. The law is settled beyond any shadow of doubt that where the principal relief failed, the ancillary or associated reliefs will also fail. See the case of Olayemi and FHA, citation captured, the case of Ogoke and Duka, citation captured, Sunko Nigeria Limited and Skybank PLC, citation provided. The above reliefs D, E, and F must equally fail, just like the principal or main reliefs. Thus, reliefs D, E, and F fail. For the avoidance of doubt and the reasons earlier given, I find that claimant's case fails. The proper order to make in this instance where claimant failed to prove her entitlement to the relief sought is one of dismissal. In view of this, the court finds that claimant's case is liable to be dismissed. Accordingly, claimant's case is dismissed. I will not end this judgment without commenting on the manner learned claimant counsel cited on reported authorities to this court in paragraph 4.12 of his final written address and paragraph 11 of his reply address at page 246 of the record. Learned counsel had referred this court to an unreported authority of this court, which is cited thus: Ibuche Stephen versus Kogi State Government and three others, suit number NICS/LKJ/02/2019, delivered on 22nd of February 2023. And also the case of Amodu Oseni Albert and Kogi State Government and three others, suit number NICS/LKJ/06/2018, decided on 29th September 2018. Also in paragraphs 4.1.11 and 4.2.7 of the same final written address, Senate Council cited an unreported case, thus Bode Thomas versus Federal Judicial Service Commission, suit number FHC/ABJ/CS/313/09, delivered on the 12th of May 2011. May I remind Learned Counsel of his duty to court when citing an unreported authority and which duty was aptly captured by the Supreme Court in the case of Chidoke and another First City Finance Limited citation captured. Thus, I quote, a counsel who wants the court to make use of the authorities cited must provide and cite the cases with clarity. That is, the name of the parties, the year the case was delivered. If it is unreported, the certified true copy where the case has been reported, the name of the law report, the year, volume, and the page. To dump authorities on the court without clear reference, that will not be accepted by this court, unquote. It is clear from the above decision that where a counsel cites an unreported decision, he has to furnish the court with a certified true copy of the said decision. Not furnishing this court with a certified true copy of the said judgments cited by Learned Counsel in his reply brief amounts to dumping authorities on the court, which should not be encouraged. They are thus discountenanced. Also, this court noticed the reckless and lazy manner of Learned Counsel for the defendants, A.D. Bello of Counsel, how he wrote his final written address. Counsel did not deem it fit to cite a single authority to this court on the issues raised in his final written address. Counsel needs to be reminded that he owes both the defendants, who are his employers, because he's a lawyer in the Kogi State Ministry of Justice, and the court the utmost duty to argue his client's case convincingly and assist the court with authorities so that he may arrive at the right decision. He's not expected to leave his address dry without citing authorities in support of his case, but relying on the court to do his duty of researching for authorities in support of his client's case. Counsel also failed to address the issues in this case. Rather, he went on the frolic of his own, talking about the failure of claimant to obtain leave before embarking on study leave, an issue that was not pleaded at all by any of the parties as espoused supra. This act is unacceptable and should not be encouraged. It is the duty of counsel to give utmost devotion in presenting his client case and to the best of his ability with professional skill. It is the presumed knowledge and professional expertise of the counsel that his client pays for and expects nothing but the best from the counsel within the tenets of the law and professionalism. In the presentation or defense of his client's case, counsel is expected to place the interests of his client, in this case, the government, uppermost, and be devoted in pursuing same to the best of his ability. He must be circumspect in the manner of presentation or defense of the case. He may make mistakes in his choice and or in the presentation or defense of the case, which is normal, but he must be seen to have exerted all his utmost efforts and applies his professional learning and skill as a state counsel. These are found lacking on the part of Bello Esquire in this case. Judgment is accordingly entered, no other cost. Parties will be afforded 3 copies of this judgment. Arise from Lokoja. Which other one?
My lord, there were other cases adjourned.
Okay, go ahead.
Case number 2 NICN LKJ 2F 2023 between Ismail Ajumai Zuriatu and 6 others and Kogi State government and 2 others. Parties are absent, my lord.
Appearances. Any appearance?
Yes,
Mhm.
I'm G.O. Salifu.
Salisu.
Salifu.
Salihu.
Salifu. Salifu.
Yes. For
For the defendant, judgment debtor.
any other appearance? Any other appearance? Mhm. Go ahead.
My lord, yeah, there was an order given against the defendant at the last adjourned date
Mhm.
that we should make a compilation of the salaries of the judgment creditors from 2017 to date.
Mhm.
The order has been complied with, but unfortunately, we are unable to file because we got it this morning.
The salaries of the judgment creditors since which year?
Since 2017 till date.
Very well. We have complied. Mhm.
With the order, but we are yet to file the process.
You have the process with you?
Yes, my lord.
So when do you intend to file it?
Today.
Very
We actually
well.
went to the registry and we were told to
Mhm.
attach a letter. So I've informed my colleague to do that and bring it to me while because
Very well. Take another date.
yes, my lord. We also have a motion, my lord.
Motion filed on 15th.
Yes, my lord.
That cannot be
No,
taken until
11th,
you-
no, 11th of April. It was filed 11th of April.
For what?
It's an order for stay of execution.
And that's what I'm saying. I can't take that until you have complied with the order of court. Is that clear?
Yes, my lord.
Very well. So what date? Court registrar.
Okay. Can we perhaps come back within this week?
File the process within 48 hours. File the compilation of the salaries of the claim or judgment creditor. File it.
Okay, my lord. So can we come back on
File
Thursday?
the compiled salary of the judgment creditor within 48 hours. Court registrar, what date?
my lord, 18th of October.
18th of October. Is it convenient?
My lord, I was thinking since we are coming back to move the motion, if we can take it within this week.
It's not possible. I don't have Lokoja sitting this week. I only specifically fixed this
Oh, my
matter
lord.
this week because of the judgment I just delivered. So
Okay, my
matter
lord.
is adjourned to 18th of October 2023 for hearing of applications.
As court pleases.
But make sure you file the compiled salaries
As
within
court
48
pleases.
hours.
As court pleases. We are most grateful, my lord.
Hearing notice to be served on the judgment creditor.
As court pleases.
Any other matter?
Yes, one more, my lord.
Mhm.
LKJ 29/2020 between Mrs. Negodu Ademu Abojenyen and one Attorney General and Commissioner for Justice, Kogi State, and 3 others. Parties are absent, my lord.
Appearances. Appearances.
From the open
Your phone is muted. Your phone is muted, Mr. Atta.
Yes. With profound respect to the Honorable Court, AC Atta, claimant, sir.
Any other appearance?
Yes, my lord. May it please this Honorable Court. My name is Oluwafemi O. Adegboyega. State Legal Advisor, Kogi State Ministry of Justice. I appear for the defendants in this matter.
Very well. The matter is for definite hearing.
Yes, my lord.
The defendant have notice of preliminary objections, sir.
The court had stated earlier, long
I believe has
time
not been.
ago, that the court is going to take it together with the main suit.
The court pleases. So my calculation was that was going to be the business of the court this morning, sir. And it's on the basis of that I was unable to contact the claimant to come to court today, sir. I am so sorry about that, sir.
Mr. Adegboyega.
My lord, Mr. Atta was not in court at the last adjourned date. He sent counsel who represented him and who stood before your lordship and heard the orders of the court.
Oh, not in this matter, in the sister case.
My lord, it was in this matter, my lord.
So
Mr.
it means
Atta,
I didn't.
on the 21st, my lord, it was on the 21st of June.
Okay.
Mr. A.B. Okoliko, I believe, if I.
Okay. Yes, Mr. A.B. Okoliko, that's true.
Yes, my lord.
Yes, he
Lord,
said
he
was holding the brief of Mr. Atta.
As the court pleases. And this matter was adjourned. We took today's date to come to Abuja. I came from Lokoja to Abuja so that the claimants can be here together with counsel so that hearing can commence. The orders of your lordship were very clear, my lord.
Mr. Atta, so what do you want the court to do, Mr. Adegboyega?
My lord, we are prepared for hearing. This is a matter that has been that has suffered a lot of adjournment. So we are prepared to go on. Your lordship made an order at the last adjourned date that if the claimant is not in court and the claimant's counsel is not ready to proceed, the matter will be struck out for lack of diligent prosecution. My lord, I will be guided by the records of your lordship.
You are right. That was the order of court.
As the court pleases. Now, my lord, the claimant is not in court and Mr. Atta is not ready to proceed. My lord specifically made the order that our notice of preliminary objection will be taken at the time we're adopting our final written addresses. So we are past that stage, my lord.
Mr. Atta, what do you have to say to that? Because at the last adjourned date, one Okoliko was in court holding your brief. And it was clear. It was made clear to him that this matter will be proceeding because the penultimate date you weren't in court. No one represented the claimant in court. The last time you were in court was on the 19th of May, 2022. And the court had already taken that decision that the notice of preliminary objection will be taken together with the main suit. And the court actually stated clearly that they should serve the claimant with a hearing notice and she should be in court, failing which this matter would be struck out today. And the court believes that Mr. Okoliko must have informed you of what transpired at the last sitting.
My Lord, may I with respect? My Lord, it is because of my Lord, sir, it is because of my inability to reach out to the claimant, sir. I should have informed her. The telephone line she gave, thinking that I would specifically take a visit to her and inform her of the date of the proceedings. She will personally be in court. But unfortunately, the record of the court is sacrosanct and correct, and I'm not disputing the record of the court. But be that as it may, sir, if she is, sir, my Lord, may I apply that the matter be taken as argued on record?
Mr. Idigbe, do you consent to the argument?
My Lord, I do not consent.
Very well.
Number one, consent.
Mr. Atta, today you've spoken from the two sides of your mouth. First, you said that the matter is for notice of preliminary objection, and that's why you didn't bother to contact your client, the claimant. Secondly, at another breath, you said that you couldn't get through to the claimant, that her telephone contact you couldn't get through. So which of the two do you want the court to believe? Because let me tell you something, Mr. Atta, I'm aware of what transpired.
My Lord, sir.
Last week, Mr. Atta was in this court,
my Lord, sir,
basically in Abuja division, here in this courtroom, to attend to a garnishee proceeding. And the court actually, I don't want to use this word, but the court put it to him that it was because he was going to get some money in that matter. That's why he appeared physically, because this matter has been on since, and Mr. Atta kept on going back and forth. He has failed to appear in this court, like the court mentioned, since 2022 May, more than a year ago. And the defendant has been appearing until the court put it to him that you had other matters you had failed to attend to. That is why Mr. Atta is here today. And instead of telling the court the truth from the bar, as you always refer to, speaking from the bar, he's telling stories. In a breath, you couldn't get to the woman. In another breath, the matter was for notice of preliminary objection. So it shows you are no longer interested in this matter. And if you know you are no longer interested in this matter, like I told you in the open court here in Abuja last week, it's better you come and, recuse yourself or withdraw your appearance for the claimant and inform her that she could get another lawyer.
My Lord, I sincerely apologize for my actions in the past, sir. And I honestly want to crave the indulgence of the Honorable Court that if I am given the last opportunity today, I will definitely ensure that I get through to her. And at the next adjourned date, she will be in the court. And if she did not come to court, I will make the appropriate application to that effect, sir. I am deeply sorry for that, sir. It is not a matter that I am slipping over it, but whatsoever has happened in the past, I sincerely apologize for that, sir. And I am begging the court and craving the indulgence of the Honorable Court that the subsequent date, if she is not in court, I will make the necessary application. That is my humble application. And I am appealing to my learned friend on the other side to please pardon me one more time for today. And subsequently, if I fail to do the needful, let the court descend with a sledgehammer, sir. I'm so sorry, sir.
Mr. Idigbe.
My Lord, I will concede to another date, but my Lord, it has to be subject to the payment of cost. My Lord, I have come from Lokoja to attend to this matter. Your Lordship asked parties or lawyers at the last adjourned date if we could come to Lokoja to take the matter, and we both agreed. And our coming here today has been for nothing. My Lord, cost follows events. This is an event.
How much are you asking for?
My Lord, I would ask for 50,000 naira, my Lord, in the light of the subsidy removal.
Mr. Atta, how much do you want to offer?
My Lord, I will.
Personal cost. You have to pay it personally and not your client.
My Lord, in the circumstances of this case, sir, well, I don't want to go into detail of what transpired and what has happened to me over this period, sir. But I am still begging the court that let the course of today be in course. That if at the next adjourned day, sir, particularly a matter that I am doing that I'm not calling for any appearance fees and all that, sir. For me to
well,
pay
that's your business. That's your business with your client. You accepted it.
My Lord, sir.
It's convenience for you to do it.
My Lord, sir. As I've appealed to my learned friend, I leave it to the discretion of the court. If the court, yes.
What date, court registrar?
Another October date in Lokoja.
October what? Give them 2 dates.
My Lord, can we go to November because the October dates are filled up?
To November.
14th, 15th November, my Lord.
No, those dates are convenient for me.
14th and 15th.
Yes, my Lord.
Yes, my Lord.
It is obvious that the claimant is not ready to proceed with her case today. Consequent upon which this case is adjourned 14th and 15th November 2023 for definite commencement and conclusion of trial. Cost of 20,000 naira is awarded against Atta AC Esquire personally. This is to be paid to the defendants on or before the next adjourned date.
As the court pleases.
The court pleases.
Any other
We are
matter?
I'm most grateful, my lord.
Any other matter in Lokoja?
No, my lord.
I rise.